All right, so I'm going to start out by introducing our speaker. Okay, so Tom has been with us for many a year. In August, reviewing the Supreme Court decisions. We're honored to have him here. It's our tradition. And today he's going to be reviewing the 2023-2024 UCI Law Supreme Court term in review. He was appointed by Governor Brown in December 2015 and has been on the bench since January 2016. He is currently assigned to an independent calendar civil court in downtown LA, and as I recently learned, he takes the bus to work. Judge Long dedicated himself to public service as well, serving twice as the mayor of Rancho Palos Verdes, 2007 and 2011, during his 8 years on city councils, 2003 to 2011. One of Rancho Palos Verdes' prominent real estate developers, Donald J. Trump, described Judge Long as both a, quote, a great man and, quote, insignificant.
You're in good company.
So Anne, can you all hear me?
Yes.
Anne and I were working with Tom Long on this, just to get the timings right. And he shared something that I thought was really important. He had to fill out a form, and he was filling it out, paper and pencil, but an alternative was online. And the paper and pencil form was not particularly clear, but he could have filled it out, something. But he wanted to clarify something, so he went online. And when he went online, he discovered that this clarification was going to send him down this long rabbit hole that would take months. And I said to him, you could have just sent it in. And he said, that wouldn't have been ethical. And I'm just so proud that we have someone in our judiciary representing our club who has a moral compass that is so precise. And would that our Supreme Court were the same.
In terms of program logistics today, Reggie's going to be sharing his screen to play the UCI Law Review video. And we've timed it so we don't have to listen to the whole video. We are focusing on what we think are the most important cases. There were a lot of cases. But we're going to pause and stop at key points. So he'll be sharing the screen of the video. And then questions for Judge Long will be addressed after the presentation for those on Zoom. And to save time, if you could for those on Zoom, if you could put your questions in chat, that will be great. And for those in person, we will take your questions. Okay, so do you want to share the first? So we're gonna do this in four videos that we parsed. And we're going to pause it a couple of times to make comments, and then at the end, we will take questions.
I want to introduce the moderator for today's panel, Professor Carrie Menkel-Meadow. She is a founding member of the UCI Law faculty. She is a distinguished professor at UCI, and she's a Chancellor's Professor of Law at the law school. Many of you know Professor Menkel-Meadow. She has taught at Georgetown, UCLA, has visited at Harvard, Oxford, and a number of other schools. She has not only influenced conversations in many fields, but she has transformed them. Please join me in welcoming our moderator for today's event, Professor Carrie Menkel-Meadow.
Thank you, Austin. Welcome, everyone, to our 14th Annual Supreme Court Review in what is the 15th year of the law school. Seated next to me is our founding dean, who I will introduce in a moment. But it's really our great pleasure to be with you in what unfortunately may not be such a pleasurable hour and a half. Shortly, you are going to hear words like improvidently granted, standing remanded. A lot of the cases were, in my humble opinion, punted. Nevertheless, as you will soon hear, the cases that were decided, and there are many of them for us to discuss this morning, have the potential to wreak havoc in the lives of many of us, probably millions of people. So it's a kind of sad morning for us to review what the Supreme Court has done. We have some questions that you have submitted that I hope we have time for. We have a lot of cases to talk about, and a lot of it has to do with what's the future of the court and the future of our country based on some of those decisions. I want to start briefly with a very short story. As you just heard from Austin, I was on the faculty of Georgetown Law School for 15 years, and I had the great pleasure when I was on the faculty to moot many of the cases that appeared before the Supreme Court. If you ever get to Washington, you want to visit the Supreme Court, but Georgetown has a mock-up of the Supreme Court itself, and we every year mooted at least one side of every single one of the cases that went before the Supreme Court. So I had 15 years of mooting a lot of the major cases in a very, very different time. I've been here for 15 years, so it was a long time ago. In 2005, John Roberts was temporarily my colleague. He was an adjunct professor at Georgetown, and he was in fact teaching in our London program when he had to fly back to prepare for his confirmation hearings. And I mention this to you because he was very grateful to Georgetown. He gave one of his first public addresses at our graduation at the end of his first year of service. And he said in that speech, probably the best graduation speech I have ever heard, and I've been a law professor for 50 years. He said he was going to try to be a consensus builder on the court. And his plan was to decide every case as narrowly as possible to try to create the biggest consensus that he could. Never in my experience as a law professor did the professors process off the stage and begin to talk about what the graduation speaker had said, substantively. Is it a good thing to decide things narrowly and create consensus? Or do we look to the Supreme Court to express and decide and explain our deepest values? So we had a very spirited discussion as faculty. Alas, 1 year later, Linda Greenhouse, the New York Times Supreme Court expert, did a follow-up on Justice Roberts' speech, and that year had the highest number up until then of 5-4 non-consensus decisions. Sadly, this year, we have almost every one of the cases we're going to talk about this morning 6-3. And as you're about to hear from many of us, many of them, not all of them, but most of them on ideological grounds. So we're going to explore some of the legal issues with you. But I want you to be thinking about, as some of you have asked, what's the future of the court? I will just briefly mention, as some of you have read in the papers, I'm also an ethicist. I've spent 30 years of my professional life trying to get an ethics code for the Supreme Court. And as some of you know, there have been questions about some of our justices and their spouses and some of their activities. For those of you who don't know, the Supreme Court is not subject to any ethical rules. Federal judges are. We have some in the audience. They have to recuse themselves. They have proceedings about when they can and can't hear cases. The Supreme Court does not. There was a proposed bill in Congress this year to change that. It didn't pass. And as I'm sure Dean Chemerinsky would tell us, even if it passed, certainly with this court, there'd be a question of separation of powers. So we're going to hear about what the court has done to us and for us. And you should all know that almost everything they've done this year has been pretty controversial. So let me briefly introduce our incredibly distinguished panel and thank them so much for coming. It's really wonderful to have them. Jennifer Chacón, my former colleague. The three of us here were part of, actually all of us here, founding faculty, so we're having a little reunion up here on stage. Jennifer Chacón is the Bruce Tyson Mitchell Professor of Law at Stanford. She has the distinction, I think, of being the one professor who's taught at the most UC law schools of anybody in the country. She began at Davis.
You just need Hastings, right?
Right, you know, University of California, San Francisco Law School. She began at Davis. She was with us for 9 years at Irvine. Then she went to UCLA, where I taught for many years. Then she went to Berkeley, and now she's at Stanford. She's an expert in immigration law, criminal law, constitutional law. And if you're interested, she will be signing books at 11:30 in the lobby of her new book, Legal Phantoms on Immigration Law and Policy. Outside, go quickly if you want that, because she needs to leave pretty soon. Next to her, our founding dean, Erwin Chemerinsky, who probably needs very little introduction. Erwin and I met 40 years ago, a long time ago, when we were both brand new professors in Los Angeles. Erwin at USC and me at UCLA.
We were in middle school then.
We were just talking about it. And as many of you probably know, he's written 15, 16 books, many books, 20 books, right? And he too will be signing his latest one. It's not his latest one, he's got a couple coming out. But Worse Than Nothing, The Fallacy of Originalism, I strongly recommend it. It's a great book, and he'll be out there signing at 11:30 when we conclude the program. In addition to his books, he's written over 200 articles. He's argued in front of the Supreme Court. And most amazing, there are many amazing things about Erwin. If you can't follow everything we say today, the minute the Supreme Court decides something, this man has an op-ed within 30 minutes. Some of his op-eds are in your materials for those of you who are getting MCLA credit. And I just want to personally thank Erwin so much for coming to join us.
Thank you for having me.
To my left is my wonderful distinguished colleague, Mario Barnes, who is also here at the very beginning. He's a Chancellor's Professor at UCI Law and the co-chair of our Center on Race, Equality, and the Law, and is also an expert in criminal law, national security law, military law, constitutional law, and his booming voice fills my heart with love. He's been my neighbor for all the years except when he left us briefly to be the dean at the University of Washington Law School. And we're so glad to have Mario back. Thank you, Mark. Next to Mario is one of our newest colleagues at UCI, Courtney Cahill, who is also a Chancellor's Professor, an expert in constitutional law, equality law, sex equality law, and LGBTQ rights. And Courtney's on our corridor too, so we have a very distinguished panel of professors to be discussing all of these cases. And as you'll hear in a few moments, she's an expert in reproductive rights, some of the important cases that were sort of punted this term. We'll hear more about that in a moment. Some of you will be interested to know what we think is going to happen. And finally, we have Kelly Perigo, who is a partner at King & Spalding in Los Angeles. We think it's very important on these panels to have people who actually practice law. Some of us have. Most of us have had some practice experience. Kelly does both federal and state appellate and trial practice. And she's going to have a little bit of the, what does this all mean for practicing lawyers, as well as reviewing some of the Supreme Court cases.
But I just wanted to comment a little bit before we went on to the next discussion of the specific cases. I think there was something that was very valuable to discuss, the notion, and I think it was true of Roberts maybe at the beginning, that he was trying to decide the cases on as narrow a basis as possible to build as broad a consensus as possible. I think pretty quickly he changed what I would expect someone in his position to be doing, which is for a long time until recently, he was the fifth vote for whatever side he wanted to be the fifth vote on, which is really a position of considerable power on his part. And also as the Chief Justice, keep in mind, he gets to appoint, if he's in the majority, he gets to appoint who writes the opinion of the court. If he's in the minority, and he's the most senior person in the minority, which he would be as the chief, he gets to appoint who writes a dissent, but I don't think he's particularly interested in writing dissents or deciding who's going to write dissents. So I think he did kind of morph from wanting to build a consensus to wanting to always be that fifth vote. And I think he achieved that until recently when it became apparent that the conservatives and authoritarians in the court didn't need his vote to piece together five. And so now in those rare circumstances, when you do see him having a controlling vote, it's because he gets someone else from among the conservatives and authoritarians to join him. And I use that label just so you understand where when I'm looking at the court, I don't look at it as being firmly split between liberals and conservatives, because there are at least two and maybe three, and we'll talk about it a little more later, who I would consider really to be authoritarians, and that's Alito and Thomas, and Gorsuch as well, although, and we're going to get to this later, Gorsuch, I think, has some interesting breaks with his fellow authoritarians, Alito and Thomas. But I think John Roberts had it right in the speech, even though it was one of his aspirations and he kind of abandoned it. I think he had it right in his speech that the best way to decide things, at least if you're not an activist justice, but you're trying to show more restraint, is to decide things as narrowly as possible, case by case. And in that way, you make sure that you don't have unintended consequences. But I think that's been abandoned by many of his ideological compatriots on the Supreme Court. And that's what we'll be hearing more about next. So let's proceed down that next path.
So we now turn to two gun cases, and they have sort of different results. And so we're going to have two presentations, and then maybe we'll have our gun experts talk about how they might relate to each other. So we'll start with Kelly. Garland versus Cahill, bump stocks.
Yes. So I don't know that I'm a gun expert, but I have now seen 6 illustrations and a GIF illustrating
Yes.
how this works. So
Explain to the audience.
yes. So this is another 6-3 decision dealing with bump stocks, which I'll explain what those are in a minute. But the National Firearms Act of 1934 outlaws machine guns. And the statute defines machine guns as any weapon which shoots, is designed to shoot, or can be readily restored to shoot automatically more than one shot by a single function of the trigger. And then in the 1980s, I believe it was, the act was amended to also include devices that can convert a rifle into a machine gun. And so the question before the court in this case is the bump stock such a device? And so what a bump stock is essentially is it's a device that gets affixed to a semi-automatic rifle, and when the shooter pulls the trigger, shoots a shot, the device harnesses the recoil energy and slides the gun forward against the shooter's stationary finger. And so as a result, it reaches the same kind of rate of fire as a machine gun. And in 2018, under the Trump administration, the Bureau of Alcohol, Tobacco, and Firearms issues a rule saying that a bump stock is a machine gun within the meaning of the act. And this is in response to the 2017 Las Vegas mass shooting, in which 58 people were killed, 500 injured, biggest mass shooting in US history. And the shooter used bump stock equipped rifles. And so in response to that, they say, ATF says, bump stocks are machine guns. So Cargill has 2 bump stocks. He turns them in under the rule. He's required to do so. And then he sues under the Administrative Procedures Act, saying that the rule exceeds ATF's agency authority under the statute. And so, as I alluded to earlier, the illustrations and the GIFs, so the Thomas majority in this case is hyper technical about how these guns work, gets really in the weeds on how the text of the statute fits with the way that the guns work in real life. And what he says is there's 2 problems with the rule under the statutory language. The first is a bump stock doesn't operate to shoot more than one shot with the single function of the trigger. And how he says that is he looks at the gun itself and what the trigger is doing. So between each shot, the trigger actually does reset. And so he says that's not the single function of the trigger in the same way that a machine gun is. So focusing on the gun rather than the shooter. And then the other piece he says is it's not automatic, because in addition to pulling the trigger, you also have to have forward force on the gun in order to keep it cycling back and forth. Sotomayor's dissent in this says, come on, there's no meaningful difference between a machine gun and a bump stock equipped rifle. I mean, at the end of the day, you've got a trigger plus backward motion on the trigger in a traditional machine gun, and in bump stock, you've got the trigger and forward motion, but it's essentially the same thing. And she invokes the statutory canon, the rule against ineffectiveness, and says you can't read a statute in a way that enables people to essentially just circumvent it. I think what's really interesting about this case is the Alito concurrence, because it's really short and it kind of just says the quiet part out loud, which is, he says, of course the Congress that enacted this statute, wouldn't have seen any material difference between a bump stock equipped rifle and a machine gun. But the text says what it says. He says it couldn't be clearer, which is interesting because, of course, the dissent reads it differently, ATF read it differently, the district court and the 3-judge panel read it differently, but he says it says what it says, and he says there's a simple remedy, just have Congress amend the statute. Which I think is also interesting because, of course, Thomas uses the fact that Congress tried and did not amend the statute to say that Congress, that this exceeds, the ATF rule exceeds the authority from Congress. But that's where we're left, is sort of what can you do, because gun innovations are going to keep being such that it's really hard for Congress, I think, to stay ahead of them.
Thanks, Kelly. Stay tuned for that one. As you will hear in a lot of these cases, while some of the justices say the text is clear and we're just following the text, textualism, others say original intent is clear, read Erwin's book. The very fact that there's a dissent in almost every case tells you it's not quite so clear, neither the text nor the original intent, or we would be having this argument in print. Thanks, Kelly. Stay tuned, there'll be more of those. So Jennifer, U.S. versus Rahimi. Kind of an interesting surprise for some of us. Erwin has a great op-ed on that one. For those of you who are interested, I think it's in our packet. Tell us about U.S. versus Rahimi.
Sure. I'm not a gun expert either. I should just disclaim that at the front, although I am from Texas, so I think that gives me the ability to talk about these things. Rahimi is an 8-1 decision, so it defies our typical split, at least in the trends that we've been talking about. Roberts writes for the court. There are a number of concurrences, most of which I won't really talk about, and then Justice Thomas writes the lone dissent, so we can see the interesting setup here. But in this case, the court reversed a Fifth Circuit opinion that would have invalidated a federal law that criminalized gun and ammunition possession by individuals subject to a civil restraining order. That is, someone who had been determined to, quote, represent a credible threat to the physical safety of an intimate partner or child, or relatedly had been prohibited from using force against an intimate partner or child. So there had already been a proceeding in which that had been established, and those individuals are barred by federal law from possessing guns and ammunition. So the Fifth Circuit held that this federal law ran afoul of the Second Amendment, as interpreted by the court in its recent decision in Bruin. So in reversing the Fifth Circuit, the court is backing away, I think substantially in some ways, from a test that it articulated very recently in its Bruin decision. So by way of a background, I'm going to give a little bit of background and then move back into the case. So less than 20 years ago in Heller, the court found that the Second Amendment provided an individual level constitutional right to bear arms. This was pretty novel, but has become sort of the accepted baseline against which all of the gun litigation that's proceeded since that time operates. So we have an individual right to bear arms under the Second Amendment, and several years later, that right was incorporated as against states and localities. And what this means effectively is that it's hard for the federal government or a state or a city to criminalize gun ownership. Hard, but this case tells us, but not impossible. With Bruin, the court really kind of made it this difficulty even more difficult, really raised the bar. The court wrote, when the Second Amendment's plain text covers an individual's conduct, that is, the individual right to bear arms, the Constitution presumptively protects that conduct. So we start with a presumption that the individual's right to bear arms cannot be trumped in any way. To overcome the presumption, the court tells us the government must demonstrate that the regulation is consistent with the nation's historical tradition of firearm regulation. So that's the framework that Bruin gives us. Is it consistent with the nation's historical tradition of firearm regulation? Now, anyone who studies history knows that there's probably not one answer to any question about what the nation's historical tradition is, and that's what makes this test so murky. And that is one of the reasons that the lower courts were such a mess when it came to trying to decide how to apply Bruin to gun regulation. And that really brings us to Rahimi. There is probably no history and tradition of disarming domestic abusers at the founding, given that domestic abuse was really not really regulated at the founding. So the Fifth Circuit held in this case that federal law in question in Rahimi must be unconstitutional under Bruin. There's no history and tradition of disarming domestic abusers. Therefore, the federal regulation is unconstitutional. The court in Rahimi this term backs away from Bruin, even as it purports to apply it. The Roberts opinion says we don't need to find an exact twin regulation of gun ownership at the founding. We just need to find something that's analogous at the right level of generality. So a gun restriction that doesn't precisely match a historical law, quote, still may be analogous enough to pass constitutional muster, end quote. So here the court notes at the time of the founding there were things like surety laws or going armed laws that were designed to disarm dangerous people, and the court says the federal regulation here is analogous to those things. Interestingly, Thomas dissents. He is the lone dissenter here, and I think he's actually fundamentally right that the court is walking back from Bruin and adopting a standard that is more amenable to gun regulation than Bruin's standard. But I think one of the things that's troubling is it's also not clear post-Rahimi how amenable the new standard is to gun regulation. How do we find the right level of generality for gun restrictions? When does that allow for states or localities or the federal government to regulate gun ownership? In her Rahimi concurrence, Jackson attacks the court's previous decision in Bruin. She says it was wrongly decided. She says that the resulting test had sowed a lot of chaos in the lower courts. And she writes, the rule of law, that ideal, key to our democracy, thrives on a legal standard that fosters stability, facilitates consistency, and promotes predictability. She worries that the court's decisions in this area are not serving that value, not offering good guidance to lower courts about what the law requires, not providing stability, not providing clarity. And I think her point about the rule of law in this case and in the area of gun regulation is one that's worth centering more generally today, because gun regulation isn't the only place, the only constitutional area where the court's decisions are increasingly parting company with those rule of law values she articulates of stability, consistency, and predictability. And I think we'll see those themes emerging across the cases that we're talking about.
Thanks, Jennifer. I don't want to force you to look in the crystal ball, but given all of that, what thoughts do you have about other efforts to restrict gun use connected to other things, like felons, for example, and those with mental health histories, as many of you know, lots of efforts to restrict the licensing and use of guns. Do you think this Rahimi tells us anything about where those are going to go?
So it's difficult to say. I think one thing we know about Rahimi is the facts were really bad for those who were seeking to challenge the regulation. And so it was, I think, very hard for this court to get behind the idea that someone with Zach Rahimi's history of violence that was sort of all over the record was someone whose gun ownership couldn't be regulated. So I think that made this case in some ways a particularly low bar and one that doesn't tell us a lot, doesn't give us a lot of predictive purchase on what happens with other efforts to regulate gun ownership. And I think that's really part of Jackson's point. That is that this is, we're still in the world where we are purportedly hearkening to history and tradition. We don't know at what level of generality we assess gun regulations when we're making those analogies. This opinion tells us a little bit, but doesn't tell us anything definitive. And I suspect we'll continue to see chaos in the lower courts, and we're really not, it will maybe depend on facts in some ways and how cases are teed up when it comes to the Supreme Court deciding whether regulations are constitutional or not.
Thanks. Mario, do you want to weigh in?
I'm just mad. Why don't you give the same amount of weight to the contemporary reality that you do to, a long ago history, which, if we certainly, the rates of women and people of color would not fare well in history. And Erwin has made some of this commentary vis-a-vis gun ownership. But I was looking at the data this morning before coming in that said 92% of women who are killed by gun violence are killed by people familiar to them, right? And so we have a problem in which there are more people who have guns than who are using them responsibly and who are posing a threat to people. And why can't we have reasonable regulation? Because, and I've heard Erwin say this, none of our constitutional rights are sacrosanct. Like the Second Amendment, the First Amendment, they are all subject to forms of government intrusion when the reasons are important enough. And I think you are right, Jennifer. We have just now entered into a territory because the individual case had such a parade of horribles. They were willing to have a carve-out, but they have not been willing to have the larger conversation about the danger posed from guns and the failure to regulate them. So I'm just, it's vexing.
And I'd go a little bit further. I think, in fact, even as it affirms the constitutionality of the regulation here, it also reaffirms the Bruin test. So it says it's applying Bruin, and it says ultimately at the end of the day we're reliant on those. So this was an opportunity for the court to step back from that, maybe to return to something that had a little bit more of a functionalist analysis, and it does not take that road at all.
Erwin, you said a little more in your op-ed. I don't know whether you want to say something.
I very much agree with both Jennifer and Mario. What's striking about Chief Justice Roberts' opinion is he never mentions the social costs of domestic violence, the human costs of domestic violence. It's entirely about how to reconcile this law with the original understanding from 1791. And I think it's crucial that this is different than any other constitutional right. It provides more protection for Second Amendment rights than any others. For all other rights, say fundamental rights like freedom of speech or protection from race discrimination, the government can act if it can show compelling interest and no other way to achieve it. But Justice Thomas' approach in Bruin says we're not going to look to whether or not there's a compelling end. He says 3 times the Second Amendment is an unqualified right, and the only regulations that are allowed are those that were historically permitted. And so what you have is a disagreement among the justices as to how to look at history, but ignoring what Mario is saying. The reason we have this law is we recognize the horrors of domestic violence in a way that wasn't perceived in 1791.
Thank you.
You know, I've always been of the view, and although I still think Rahimi is a very favorable, one of the few favorable decisions this year, and one of the few recent favorable decisions on the gun rights issue. The Second Amendment issue to me, though, always still comes back to the 4 words which are always forgotten, that are the first 4 words of the Second Amendment, which are a well-regulated militia. So, you know, I predict, maybe I'll be wrong, but I predict that over time, Bruin will die the death of 1,000 cuts, just the way Roe versus Wade did, and that it'll be distinguished away and ultimately become little or nothing. What I thought was interesting about Rahimi is the idea that you could have regulation that was analogous to what existed back in the 1700s and 1800s. And apparently one of the things I learned reading that opinion was you could require bonding people to carry weapons, financial bonding. So I could foresee the possibility that a very analogous regulation might simply be in the future to say that someone who wants to carry a gun has to have insurance. The same way you have to drive a car. Of course, what this would do is restrict the right of carrying guns and gun ownership to those who are well off, because it'll be expensive to get the kind of insurance. The kind of insurance I would have in mind would be, I don't know, $1 million liability insurance. And that would be expensive. So the right would quickly become the right of only a privileged few, which I think the current backers of the right wouldn't really care very much about, since that's who they're primarily concerned about anyway. So, but we have seen already one recent Fourth Circuit decision where we've seen, I believe, a favorable ruling in favor of a state's law against assault weapons. And I'm thinking that Rahimi may be a basis to expand some type of regulation, some type of gun control. So it'll be interesting to see what happens as we move forward. Let's go to the next passage.
Okay, and if all of that isn't depressing enough, we now turn to what may or may not remain of reproductive rights. So, Courtney, we're going to do 2 cases. I'll let you start with FDA versus Alliance for Hippocratic Medicine. Hippocratic Medicine, excuse me. So for those of you who were here 2 years ago, and on this stage we had to deal with Dobbs, the Supreme Court did 2 cases having to do with abortion. And this is where we're going to see a little punting and moving away from deciding anything. So why don't you begin with FDA, which is, for those of you who don't know, the abortion pill methylhistone case. Courtney.
Sure. So this is a Alliance for Hippocratic Medicine versus FDA is a rare example of unanimity on the court. So this was a consensus decision in an otherwise non-consensus term. So this case was about the legality of the medication known as mifepristone, which is the most common form, which accounts for more than 50% of all abortions in the United States, of course, only in those states that still allow abortion rights. So here, a group of pro-life doctors and activists that collectively are represented by this Alliance for Hippocratic Medicine argued that the FDA abused its authority under the Administrative Procedure Act when it, one, approved mifepristone in nearly a quarter of a century ago in 2000, approved it for use in medication abortion. And two, they argue that the FDA continued to abuse its authority when it started to lift restrictions on the use of mifepristone, especially during COVID. The main restriction that the FDA lifted, of course, was the in-person requirement. So previously, the FDA had required a patient to go into a doctor to meet in person with a doctor in order to get the prescription for mifepristone. During COVID, the FDA lifted the in-person requirement and allowed the abortion pills to be shipped through the mail. So the doctors are arguing, look, this is an abuse of the FDA's authority under the Administrative Procedure Act. They found a sympathetic ear of a federal district court judge in Amarillo, Texas, who said the FDA exceeded its authority in not only in lifting the restrictions during COVID, but in approving mifepristone in the first place nearly a quarter of a century ago. These doctors found a somewhat sympathetic Fifth Circuit that upheld much of the lower district court's ruling. But then the FDA appeals to the United States Supreme Court, and in this decision, the court dismisses the case, not on the merits. So the court says nothing, it's a 9-0 decision. The court says nothing about the safety and efficacy of mifepristone, which has been beyond proven for decades now. Rather, they dismiss the case on standing grounds, right? So in order for a plaintiff to get before a federal court under the Constitution, among other things, that plaintiff must have standing. So what is standing? Basically, it's the idea, right, that the plaintiff must be able to show an injury or an imminent injury that is caused by the defendant's conduct. In this case, so basically, standing requires a plaintiff to show that they're not a mere bystander of the defendant's conduct, but they have skin in the game. And what the Supreme Court said in this case was that the pro-life doctors and pro-life activists who were suing the FDA, they were mere bystanders. They didn't have skin in the game because federal law already doesn't require them to play the game. So what do I mean by that? I mean this. Shortly after Roe was decided, Congress responded and states responded with laws that basically told doctors and other medical personnel that they didn't have to perform abortions and they couldn't be fired for choosing not to perform abortions if abortion violated their deeply held religious and moral conscience, right? So there's a whole slew of very robust federal and state conscious protections for doctors. So what Kavanaugh, who wrote this decision in the standing case, said, look, federal conscious protection already doesn't require these doctors to participate in any abortions. They were trying to argue that they had standing because it was a very far-fetched theory of standing that both the district court and the Fifth Circuit signed on to. And that was this, that the FDA approved mifepristone in 2000, but they did so erroneously because mifepristone can be dangerous. Women taking mifepristone might suffer complications from mifepristone. Those complications might land them in the emergency room. One of these pro-life doctors might be in the emergency room and they might be forced to serve a woman. They might be forced to actually participate in kind of an abortion that goes against their religious beliefs. So the district court bought this very far-fetched theory of standing. The Fifth Circuit bought this very far-fetched theory of standing. And what the Supreme Court says in this case is that no, right, because of these robust federal conscious protections, you don't have to participate in an abortion that maybe was caused, right, or complications from an abortion that perhaps were caused by mifepristone. You can opt out and let somebody else do it for you. So in a nutshell, the court says in this case, you're just a bystander. You don't have any skin in the game. You know, the fact that the FDA approved mifepristone is nothing to you. So that was the mifepristone case. The other case is
Before you get to the other case,
Yeah.
you've just set it up very nicely for a law professor's hypo, okay?
Yeah.
So we're about to hear about Moyle versus Idaho, which deals with some of those emergencies.
Yeah.
So try to imagine that we're in Idaho, and one of these religious doctors is there, and someone does in fact come in with some complication from mifepristone, and he's the only doctor, or she's the only doctor there.
Yeah.
Then what?
Well,
Now you can explain the second case.
Okay, so right, so Moyle versus United States is a case about a conflict between two laws. What are those two laws? Idaho's total abortion ban on the one hand, and a Reagan-era law called EMTALA, which stands for the Emergency Medical Treatment and Active Labor Act. So what do these laws say, and what's the conflict between them? Idaho's total abortion ban makes abortion a crime in Idaho unless it is necessary to save the life of the pregnant patient. EMTALA, this federal Reagan-era law, says that hospitals that receive Medicare funding who take Medicare patients, they have to provide emergency stabilizing treatment to people who come into the emergency room, right? So these Medicare-funded hospitals cannot turn patients away, including patients who are in active labor, as the name of EMTALA suggests. You cannot turn them away because they cannot pay, right? So Congress passes EMTALA to address the problem of hospitals turning uninsured patients away. So those are the two laws. What's the conflict? The conflict is there's a gap between them, right? So Idaho's law says no abortions unless they're necessary to save the life of the pregnant patient. EMTALA says the hospital has to provide stabilizing emergency care, right? So meaning they have to provide the care to protect the health of a patient, right? So Idaho's position in this case is that EMTALA doesn't apply here, right? Because in our state, you can only have an abortion, right? A woman can only have an abortion unless it's necessary to save her life, not if it's necessary to preserve her health, including, of course, her reproductive health. The federal government, predictably, is arguing that the Idaho abortion ban is partially preempted by EMTALA to the extent that the ban wouldn't allow the stabilizing care that EMTALA requires, right? So this is a preemption case. The lower courts, the district court in this case, agreed with the federal government. The Ninth Circuit agrees with the federal government, although there wasn't a full judgment before Idaho appealed this to the Supreme Court of the United States. So they appealed in an emergency petition asking for EMTALA to basically to be stayed in Idaho pending the litigation. In this case, this Moyle versus United States, it's a 6-3 decision. The court dismissed the case, again on procedural grounds, dismissed it for being improvidently granted, known as a dig. So they said, basically, they dismissed the case as improvidently granted and they lifted the stay. So for now, emergency abortions in Idaho are allowed in order to preserve in order to avoid the death of the pregnant patient, as well as to preserve the health of the pregnant patient for now. Why did they dismiss it? Why did six of the justices dismiss it for being improvidently granted? It's hard to say. Justice Barrett wrote a concurrence onto which Roberts and Kavanaugh signed, saying that there were certain arguments, that certain things, certain issues that came up during oral argument before the court that gave her pause, that she would like for the case to be for a full judgment to happen at the Ninth Circuit before they weigh in again on this issue. So yes, both of these cases, you might have read in media summaries of these cases that these cases are a victory for reproductive rights. I hate to be the sort of Debbie Downer in the room. I don't think they're victory for reproductive rights. I think, they're just kind of preserving the status quo for now. If anything, I think both decisions actually lay the groundwork for further eroding reproductive rights down the line. Both of the decisions, as Carrie just said, really are really signaling to the Biden administration, right, which, is sympathetic to abortion rights and disagreed vehemently with Dobbs. They're signaling this. Look, you might try to get around Dobbs, but you cannot get around federal religious conscience protection for doctors, right? So you might require hospitals to to provide stabilizing care to women, which might include, abortion care, but doctors in those hospitals can always opt out, right? And this case, the Moyle case, goes pretty far. Goes even further by suggesting that they can opt out. At least 3 of the justices made this suggestion that they can opt out even if there's no one else in the hospital willing to perform, even if there's no one else in the hospital willing to give a woman stabilizing care to preserve her health in the event of a health emergency.
So now we're going to move to what is a pretty technical area for lawyers, but pretty significant for all of us. And that is, as many of you have heard in the rhetoric during the election season, the complaints that many Republicans have about our administrative state. This court has done severe damage, I would say, to the administrative state. We've got about 4 or 5 cases this term that deal with it. We're going to start. Erwin's going to comment on Loper-Bright Enterprises, which overruled a long-standing, over 40-year precedent of Chevron deference to what administrative agencies do in the way court reviews regulations. And you've already begun to hear about some of the regulatory cases this term. So Erwin, tell us about Loper, and then if you want, without preventing us from getting to Trump, that I know everybody's here to listen to, if you wanted to talk about EPA or some of the other regulatory cases. Go ahead.
Let me just start by saying how wonderful it is back home at UCI. Thank you so much for inviting me. I also want to say a word to echo the theme you started. If I was to have a theme of this term, it's a court divided. I counted this morning, there were 59 decisions this term, opinions after briefing or argument. 23 of them were 6-3, and 5 of them were 5-4. And even in cases that were unanimous or nearly unanimous, there were so many opinions. Rahimi was 8-1, but there were 6 opinions. Also, the tone of the justice in so many cases was much more rancorous and angry. I once read that someone described the Supreme Court as 9 scorpions in a bottle. I would describe the court this term as 9 angry scorpions. In terms of administrative law, I so agree with Carrie that one of the most important changes in the law during the Roberts era has been cutting the powers of the administrative state. In the last couple of years, the Supreme Court created a brand new doctrine to limit the power of administrative agencies, the Major Questions Doctrine, that said that an agency can act on a major question of economic or political significance only if there's clear guidance from Congress. The court used it 2 years ago to say the EPA couldn't regulate greenhouse gas emissions from coal-fired power plants. The court said last year that the Biden administration couldn't give student loan relief. Ask yourself the following: what's a major question of economic or political significance? What's enough congressional guidance? The Supreme Court hasn't said, so it's opened the door to challenges to every kind of agency regulation. I spoke in DC last fall, and lawyers said to me, our clients think Everything is a major question and want to bring a challenge. Now the Chevron doctrine. In 1984, in Chevron USA versus Natural Resource Defense Council, the Supreme Court said when a federal statute is ambiguous and an agency is interpreting it, court should defer to the agency interpretation. Example, the Clean Air Act says that the Environmental Protection Agency can regulate air pollution. If the EPA decides only a certain amount of a particular pollutant for the air, court should defer to the agency with regard to that. Chevron deference on the idea that the agencies are experts and Congress can't legislate with great specificity. Chevron was a unanimous decision 40 years ago. But last Friday, the Supreme Court, in a 6-3 decision, expressly overruled Chevron deference. Chief Justice Roberts wrote for the court, Justice Sotomayor wrote a blistering dissent. Chief Justice Roberts said, under the Administrative Procedures Act, it's for the court to interpret the statute. No deference is to be given to the agency interpretation of the statute. Justice Sotomayor talks about how this is just an enormous change in the law. They'll put in jeopardy health and safety regulations, regulations of the environment, regulations of business. What will it mean in practice? Well, the reason that business has long wanted to overrule Chevron deference is to make it easier to challenge government regulations in the court. And I think you're going to see an enormous increase in challenges to government regulation in the courts and many more government regulations overturned. The day before, the Supreme Court decided another case that limited the administrative state. There's a case called Securities and Exchange Commission versus Cherkesy. Federal law says that the Securities and Exchange Commission can impose civil penalties when somebody violates federal security laws. Cherkesy and his business were accused by the SEC of violating federal securities law. It went before an administrative law judge. The judge found a violation. $300,000 in penalties were imposed. The Supreme Court, once more, 6-3 reverses. Chief Justice Roberts writing, Justice Kagan writing a vehement dissent. And Chief Justice Roberts says, agencies can't impose civil penalties. If there's a desire for civil penalty, it has to go to federal court where there's possibility of a jury trial with the Seventh Amendment. But as the dissent pointed out, there are over 200 federal statutes that authorize agencies to be able to impose penalties. All of these are now questionable constitutionality, and it goes beyond that. Think of federal statutes that provide for mandatory arbitration, where there's possibility of civil penalties. If an agency can't impose civil penalties, then I don't see how an arbiter can impose civil penalties. So all of this is a tremendous shift of power away from agency expertise and towards the judiciary.
So, since you quoted Justice Sotomayor, Justice Sotomayor has some fabulous one-liners in her dissents. We'll get to one in a moment. But on this one, Justice Kagan said, the court is now hubris squared. Seriously, so what you've just heard Erwin describe, and we see in a bunch of the cases, this court has decided that more and more important questions are only for the courts to decide. And there's a lot of discussion in these cases about who's got expertise. And we have decades of deferral to the expertise of agencies and also to the fact-finding that goes on at the agency level, where we have experts looking at environmental, health and safety regulations, workplace regulations. I worked a lot when I lived in Washington on negotiated rulemaking, where there was deference to the way agencies decided things. And as Erwin says, and as Justice Kagan says, the court is aggrandizing itself as being the only agency court decision maker in all of these cases. And a lot of these cases have this kind of interesting separation of powers theme in it. And I think Justice Kagan and others of us think they are now usurping a lot of other separation of powers, places where Congress or other parts of our government had been the decision makers. Stay tuned for the Trump immunity case. We're keeping you in suspense just like the court did to us on Monday morning. And so now, the reason you're all here, well, you may be here for many reasons, but we've kept you long enough to be in the weeds of all of the complicated decisions by the court. We'll turn to the two cases involving Trump's behavior. We'll start with the big one, which came down on Monday morning, and that is U.S. versus Trump, Trump's immunity, presidential power. So
I'll start us.
you want to start, Mario, and then we'll have Erwin.
I'll give the factual background and a very little sort of commentary and then open it to Erwin, which is, I think most people know that after the election of 2020, Trump engaged in a pattern of conduct in which he basically denies the results of the election and attempts to obstruct the counting and certification. And ultimately, it leads to a federal grand jury indictment on 4 counts criminally. And what happens, he and his team go into a district court in DC and challenge that he has broad and absolute immunity from criminal prosecution based on actions taken while president. That is rejected by the district court in DC. It is also rejected by the DC Circuit Court. Interestingly, they did not decide the question of whether the underlying conduct was official or not. So that question they didn't answer, but they did answer no to the question of absolute immunity. It comes to the High Court and a 6-3 opinion written by Justice Roberts, to which I think there are compelling and cogent responses from both Justice Sotomayor and Justice Brown Jackson. So the long and short of it, and this is half glass full for a lot of people in the press on it, was this distinction between official acts of the president and unofficial acts, and those things for which he enjoys a broad immunity, and those things for which he does not, and what happens potentially for those things are unofficial. So in some ways, people were selling, well, he didn't get full and complete immunity. There is this distinction, but I think if you read the language of the majority opinion, it's frightening. Because what it says is he, in a sense, does enjoy a type of absolute immunity and a presumption to it for a set of activities that it describes even within the outer perimeter of the things for which he enjoys official responsibility. And they do clarify it's things for which there is a specific constitutional commitment of executive power. He might enjoy less immunity for shared responsibility items for which it's the president and Congress. They also go on to tell us that now district courts are going to have to figure out what is official and unofficial, but they caution them to be careful, because they seem to suggest that even things that seem to be remote from presidential power could be covered, so much so that they suggest that you're going to have to be careful that none of the evidence you try to admit against the president, even one who is acting unofficially, not touch on any of their actual executive power. And so, I mean, even though there is this distinction between official and unofficial, I find the language sweeping, right? If you think about a case like Nixon, where the president made a claim about absolute immunity in the context of privileged communication, and the court says, absolutely not. What you enjoy is a qualified immunity for a subset of communications, especially for things that are national security and the defense of the nation. There's no such qualification here. It's sort of official, unofficial. We will broadly interpret the things that are official, and now we're going to kick it to the lower courts to start doing that work. What each of the dissents do that people sort of took issue with is give these very horrifying examples that could actually be immune from prosecution, and Justice Roberts says they were fear-mongering. And this is one where I think you think about the justices just living in two different worlds. But I'll turn it to Erwin.
But before Erwin, I'm going to just say 2 quick things. I always tell my students, I bet these guys all do too, if you want to get a sense of what it's like to live in alternative realities, read a majority opinion and read a dissent. And in this term, we have a vast literature on that to see that justices on different sides literally live in different worlds. As law professors, ever since this case came down, all of us have been generating, as the court did, all the hypotheticals that come off of this case. So we can talk about the fear-mongering ones, but just take from the Nixon era, some of you know. When Nixon was president, he asked the IRS to target his enemies for tax audits. Is that covered? Is that an official act?
Yes.
Yes. Go ahead, Erwin. Take it away.
I very much agree with Mario's description. Let me just say a little bit more about what the justices say, and then to say a word about what I think of the decision. Chief Justice Roberts seems to draw a distinction among 3 kinds of presidential acts. One would be official acts, and he defines official acts as anything done in carrying out the constitutional powers of the president or anything done pursuant to statutory authority. And he says the motive of the president doesn't matter and shouldn't be looked at by the court. Then he says there's a zone of activities that are at the outer reaches of the president's authority. And he says for that, there's presumptive absolute immunity. And then he says there are the private acts of the president, and for that, there's not absolute immunity. And he tries to use that as a reassurance towards the end of the opinion. Well, think about what the indictment was about by Jack Smith. One part of it was the misuse of the Justice Department trying to undermine the 2020 election. The court is clear that that's protected by absolute immunity because it's communication with the president and the Department of Justice. President Trump trying to get Vice President Mike Pence to give him the election when the votes were cast. The Supreme Court says, well, that's unclear, but that seems to be in the presumptive category. What about President Trump pressuring state officials, like in Georgia, to find votes for him? Or what about what President Trump said on January 6th? The court said it was going to remand that to the lower courts. But I thought it was telling that the court didn't on its own say that's in the private category. What about the convictions in New York? You might have seen the news this morning that there's an agreement to delay President Trump's sentencing to allow him to argue absolute immunity. I don't see that as even possibly within the official or the outer boundary. That seems so clearly private. It's asking that business ledgers be falsified to hire. So I think it's frivolous to say that that's protected by absolute immunity, but we'll see. As Mario says, both Justices Sotomayor and Jackson write blistering dissents. Justice Sotomayor does give the example. She says, what if the president orders Navy SEALs to go kill political rivals? That's the president as commander-in-chief. Core constitutional power. Motive doesn't matter. The president choosing to use the Justice Department for political retribution to prosecute rivals. That's clearly protected by absolute immunity. The president taking bribes to give pardons. A core power of the president is being able to issue pardons. So all of these, Justice Sotomayor says, quote, immune, immune, immune. I thought that Justice Jackson, in a footnote, very powerfully put this. She said, there's no doubt that the president has the power to fire the Attorney General. The question is, does the president have the power to poison the Attorney General? And this would say absolute immunity. So I think that in hindsight, this will be on the list of the worst Supreme Court cases ever. And I know it sounds like hyperbole the day after the decision.
They had to replace Korematsu with something.
Oh, no, I didn't say at the top of the list.
Plessy, you forgot Plessy,
Dred
Mike.
Scott, Plessy, Korematsu will be in the Hall of Shame forever.
Yeah.
But so will this case. And that's because the very core of the rule of law is that no one, not even a president or former president, is above the law. And what this says is that the president, in using constitutional powers, no matter how much it's illegal, no matter how much it's an abuse, has immunity, I think, for both criminal and civil liability. That can't be reconciled with the most basic principles of our democracy.
And as Sotomayor said, what this court has now done is made the president the king. A little appropriate before July 4th for us to consider what that actually means. So let's just spend a moment or two before we close on the other Trump case, and that is U.S. versus Fisher, which had to do with the indictments of several of the January 6th insurrectionists. Erwin, do you want to summarize
do
for
this
us?
quickly.
Mm-hmm.
The Sarbanes-Oxley Act that was adopted in 2010 has a provision that says that it's a federal crime to impede or obstruct official proceedings. And this was one of the counts in the indictment of those who were prosecuted and convicted in federal district court in Washington, D.C. The Supreme Court, in a 6-3 decision, but not with the usual split among the justices, found that this statute is limited to engaging in obstruction or impeding that relates to documents. So that's really what the Sarbanes-Oxley Act is about, is something that relates to records, documents, that they won't read the so-called catch-all provision in the way in which the literal language would suggest, What's interesting here is Justice Barrett wrote the dissent, joined by Justices Sotomayor and Kagan. So what does it mean? Well, for all of those who were convicted after January 6th under this count, this conviction is likely overturned. But all of those who were convicted on other counts as well. So it's not likely to mean that any overall convictions are reversed, but resentencing. And in terms of this count of the Trump indictment, if it's not protected by absolute immunity, I think there's an argument that President Trump was trying to change how the ballots were counted, and that goes to documents, so maybe the law can still be applied. But it's a narrowing of the federal statute to say this just applies with regard to documents, records, not just obstruction of a proceeding.
Okay, well, before we do some answers, I wanted to make some comments. I think if you take away nothing from this session other than U.S. versus Trump was, as Professor Chemerinsky suggested, the worst decision in history, it may well be. It's definitely up there with Dred Scott, Plessy versus Ferguson. It's right up there in terms of what its impact is. But what I thought was interesting, and the speakers didn't discuss it, is it was not really, we get some of these fragmented decisions. It wasn't really 6-3, it was really 5-1-3. Because Amy Coney Barrett wrote her own concurring opinion, and she didn't join in all the aspects of the opinion of the court. And in fact, she indicated that on some issues she agreed with the dissent. And I think, who knows, in the conferences and the negotiations leading to the issuance of the opinion, how much negotiation there was. But I, for one, would like to see some of the members of the Supreme Court, who I think write wonderful dissents. The very best dissent is not as good as the very worst opinion of the court, if the result is what you're after. So I would have liked to have seen more effort made to sort of draw in Justice Barrett. What I think was interesting about her point of view is she doesn't look at it from the viewpoint, she put immunity sort of in air quotes, and she said, really the issue in immunity is there a statute purporting to limit the authority of the president in the first place? So for example, she used the example of the president orders a hostage rescue mission that results in killing someone. And there is a statute that says you can't kill people outside of the country. You can't order their killing, but you can't order their unlawful killing. So she would say in the first view, you do the analysis, and unless the statute prevents the president from doing something, you don't really have an issue. If it does prevent him, then you analyze whether or not the statute is constitutional or not. And that's how you decide whether or not the president is immune from prosecution under that statute. And she also raised the point of view that she would have rather dealt with the indictment now. And I think that's a reasonable point of view. Why are we sending it back down to the trial court below, only to tell the trial court, here's some vague general guidelines we're giving you, but you figure it out. You figure out what portion of the indictment goes forward to trial. I think what Justice Barrett was suggesting, and I think would have been a reasonable approach, would be, no, let's go through the indictment right now. If we have articulated a good standard for immunity, we should be able to say what portions of the indictment survive, what portions don't, and let the matter go to trial as soon as possible. I think U.S. versus Trump is going to turn out, unfortunately, of being an exemplar of the justice delayed, the old saying, justice delayed is justice denied. Because whatever happens now, there'll be motions to strike portions of the indictment. Whatever the decision on those motions is, somebody will appeal, I guarantee it. And there will be no trial before the election in November, which is very, unhelpful in terms of making real progress. So, that probably, I thought the most impressive thing in reading through the discussion of the immunity as well was just the fact that historically, the founding fathers did not want the president to be like the king. They did not have the view that he was going to have sovereign immunity. In fact, according to some of them, it was the case that at the Constitutional Convention, it was considered that whether or not the president would have immunity. and it was specifically rejected. And also in the Constitution, there is a very specific limited immunity for those people who are in Congress. And it covers things like speech and debate on the floor of Congress. It covers things like going to the congressional session and coming back. They can't be arrested while they're going to and coming back. And it's a very limited immunity. So when the Constitution expressly creates a limited immunity, but it mentions nothing else, that is at least an implicit assumption that is rejecting a broader immunity. It's an old custom that, lawyers sometimes have of having various Latin phrases that mean something, and I'm not sure I'm saying it right, but I think it goes something like inclusio unius est exclusio alterius. So if by mentioning one thing, you create an implication that the things that you don't mention are excluded. Well, we know there's immunity for members of Congress in very limited circumstances. That's mentioned in the Constitution. So implicitly, that means there isn't broader immunity for anyone else, in particular, including the president. And it was interesting also reading the beginning of Thomas's opinion about how, can you imagine anything worse than the idea that a president might be prosecuted, but thankfully that's not permitted under our Constitution. And I thought, how can you not imagine anything worse than that, number one? But number two, we got by for over 200 years without having to really worry about whether or not the president had immunity. I guess you could say we did have to worry about it under Nixon, but the reality is I don't think he claimed all sorts of privileges, and he tried to withhold tapes, and he tried to obstruct justice, but I don't think he ever claimed that he was immune. Maybe he should have just had Trump's lawyers, and he should have just said, hell, I could shoot people on Fifth Avenue, and I could, order killings of my opponents. And so if I can do that, what I did is trivial by comparison. Maybe he should have made that argument. I don't know. So we were going to open it up for questions at this point.
Right.
And I think what I want to do is stand.
Okay.
Too much sitting for me, so I'm going to go ahead and stand over here. Because I need the microphone as well. Do we have a microphone? We can have?
No, this will shit.
Oh,
Okay, so we're first going to take a question from the audience, and then we'll pick one from Zoom. So,
two of the cases, all of it is upsetting. But what I wanted to know is, okay, we have the convention starting, and I haven't had the chance to scrutinize our list of things we're approaching, but I know that Biden said he wanted to change the balance of the court. I've been a really strong proponent of modifying, particularly the federal court structure to create more expertise zones, things like that. So do we have a study panel did the Democrats have a study panel on how to put that in place? And do we have a position on that to vote on changing that in the convention?
well, I don't know the answer to that question. I suspect the answer is no. I guess what I would say, here's the problem with changes to the Supreme Court. Almost all of them would require a constitutional amendment, which is extremely difficult. Now, you could expand the number of members of the Supreme Court. In the past, it's had as few as 5. At one point, it had as many as 10. 9 is just a custom, and you could do that. You could also take the current Supreme Court, I think, although they would probably object to this, and you could say, we're only going to give them, I think the provision in the Constitution that gives them jurisdiction says they have original jurisdiction over this limited category of things, disputes between states, disputes involving ambassadors, foreign states, et cetera, and such other appellate jurisdiction as Congress may give them from time to time. Well, you could say, okay, we're not going to give them any other jurisdiction. There'll be the Supreme Court of original jurisdiction. We'll create a new Supreme Court that'll cover other things. But almost anything you do, whatever you do, you have to think about 10 years from now, 20 years from now, what's the other side going to do?
What do we do as a group to get a study panel in place in our party to work on that? Can we petition for it?
No, they are.
I'm sure there are going to be people trying to formulate ideas, and one idea would be to what Franklin Roosevelt tried to do, which would be to pack the court. That you can do without a constitutional amendment. Well, you may, and it's a very, it's a very difficult issue.
This group, do we have the ability?
I don't see why you think that would be up to the club.
Okay, I'm gonna, before I go online with you, I'm gonna take another one from the audience.
And repeat the question, so you can hear the question.
What, her question?
Yeah.
It had, her question was the same thing, you know, she wanted to know if our club could tell the Democratic Party to study this.
The study
To reform the.
Okay, this is,
Okay, with you're saying this, immunity case is maybe the worst. And a few others to follow. What can be done about it? Does there have to be another case brought forward in a future time that then reverses this? I mean, what can be done to change this back? Yeah, if anything.
Yeah, yeah. Okay, so as to US versus Trump, what can be done to change it back? Well, you know, I guess obviously the easiest thing to overrule existing case precedent is to have another case in the future. I'm not so sure we want that, because that would mean we'd have to have another president doing things that gave rise to a real issue of immunity. It's not enough to just be a theoretical problem. It has to be a real problem. And other than Donald Trump, and Richard Nixon, I don't think we've really had any presidents historically who created problems that would give rise to another need for immunity and deciding the issue. I think all you can hope for is that if you get better appointments to the Supreme Court and the issue comes up again, there'll be a better way of dealing with it in the future.
okay, Mayor, you can, okay, ask your questions.
Yeah, the two-part question. First, those authoritarian justices, Alito, Thomas, Gorsuch, have they always had this authoritarian tendency, or is this a recent change of opinion based on Trump and Trumpism? And second part, regarding this.
Before you go on, I can only take one at a time, because that's it. So let me try to answer the first one. I would say, yes, their viewpoints have been what they've been since they were appointed. They were sought out, and the Republicans have been very careful in gathering conservatives and Republicans and gathering a group called the Federalist Society that vets judges and tries to pick judges that are very conservative. But I will say studies have shown that over time, as they serve on the Supreme Court for longer periods of time, most Supreme Court justices, but particularly the more conservative ones, tend to drift to the left politically over time. And we've seen that in a number of cases. I'm cautiously optimistic we may see it in the future. I think to some degree we're already seeing hints of it in Justice Barrett.
Yes.
And even from time to time in the case of Justice Gorsuch, that we're seeing them take opinions that they actually get pilloried for by their colleagues. And this is why I always think it's intriguing when, you know, one side or the other, and both sides are guilty of this, pillories their own sort of ideological allies. It doesn't make any sense. All it means is you're writing a snazzy dissent. And as I said before, dissents, you don't want to write dissents. You'd rather write, you know, opinions of the court every single time, or concurrences at a minimum. Every time you're writing a dissent, it's a failure, and it's unlikely to have any meaning, really, except maybe in history books 50 years or 60 years from now. So if you're trying to achieve something today, I guess, you know, everyone on one side of the ideological fence or the other ought to make sure that our justices and judges read a book like How to Win Friends and Influence People, because you'd much rather be, you know, in a 6-3 split, you'd rather be in the 6 than the 3 without having to give up your values. You had a second question.
Yes, regarding the Trump immunity case, do you believe that these justices are voting based on their philosophical view? Namely, if this was a Democratic president who had committed January 6th, would they still be voting the same way? Or is it mostly loyalty to Trump that's driving them to vote the way they did?
Yeah, would they vote the same way if the roles were reversed? In other words, if it had been a Democratic president, standing in front of the Capitol or the White House saying, let's march down to the Capitol and prevent them from stealing the election. Let's do something. I will be with you, or whatever the words were. I think that the answer to that is many of the current justices, I forget which ones, but had a prior history of serving as in the White House as part of the group of counsel to the president. And as a result, they kind of are bought into the idea of a lot of executive power. Justice Barrett, I believe, does not have that history, which I think explains her position in the immunity case. I think that that's really more of an influence. I don't think their ruling on it is transparently political. I think their ruling comes from a notion of very broad belief in executive power. But I could be wrong. I mean, I used to always think that conservative judges at the appellate level were consistent in being true defenders of judicial restraint. Not anymore. And that's part of what we're seeing in some of these. If you're a true believer in judicial restraint, you're not going to overturn half-century-old precedent like Roe versus Wade. And there are a whole bunch of other things you're not going to do, like simply throw away the deference that have been given in the past to regulatory agencies. So that's also a very disturbing case, overthrowing Chevron.
And why don't you have them come up and,
Well,
okay.
Some of these cases that are being brought are like they shop around the circuit or the judge. Like it's very controversial cases that they're trying to get to the Supreme Court, like to overturn precedent. How does that whole process work? I mean, are you allowed to then choose some obscure, Texas and Amarillo, and then
Or really obscure me. But that would be, yes. The question was basically, can people shop around and pick a case and set their case up to be decided in Amarillo, Texas, instead of New York City, et cetera, et cetera? And the answer is yes. And the appellate courts should be observant and a little more skeptical. And I think they were, and I think they actually shot themselves in the foot bringing the case you're thinking of in Amarillo, because I think it alerts the upper level courts. And of course, they ended up losing that case involving the prescription-based abortion pill. I think that it alerts the higher court to, they themselves, the litigant, recognizes the lack of merit in their case because they went out and shopped for the venue and did forum shopping, we call it. And it's perfectly legal to do it in most cases, but it's something that I think appellate courts are looking to stamp out. And I certainly, when I see it at a state level, if I've got authority to stamp it out, you're bringing the case in front of me, even though all the witnesses are either in North Carolina or Arizona or something like that, and there's no connection to California. If I have authority to dismiss that case or transfer it, I will look at doing it.
I have a question on the immunity issue. If we are fortunate enough to get a Democratic Congress, Senate, and a president, can they write laws that overturn what the Supreme Court has decided on?
That's a very good question. I hope everyone heard that. If a party gets a control of all three branches of both branches of Congress and of the executive, So House, Senate, and President, can they write laws that will overcome the Supreme Court's ruling? Yes, maybe. If the ruling is based on the Constitution, no, because the Supreme Court will simply be able to say, well, and I think they're saying in the immunity case, the Supreme Court is saying, well, the president has constitutional immunity. But this is where it would make a difference, and where Justice Barrett's viewpoint would make a difference. If the approach is that the Supreme Court is saying the president can or cannot do something because of the interpretation of a statute, like the issue of machine guns. Oh, if you ever want to look at an opinion, go look at that opinion involving machine guns, because unless you're a mechanical engineer, you're not going to understand it and all the drawings that it comes with. I mean, it's just preposterous. My dad was an electrical engineer. I didn't want to be an engineer. I went to law school, and now I'm reading these things, and apparently I have to be a mechanical engineer to understand what a machine gun is. Who knew? But if it's an interpretation of a statute, then Congress can rewrite the statute. But if it's a constitutional provision, then it's going to become an issue of whether or not you can get a constitutional amendment, which is much, much more difficult.
Well, we have a question from Sally. Do you want me to say it, or do you want to unmute, Sally? Well, okay. I think President Biden is proposing 18-year terms for justices and some other reforms. What do you think about this?
Well, I think, first of all, I'll be retiring long before 18 years myself. I'll be retiring at age 70. By that point in time, I'll have been on the bench about 11 or 12 years. And that's only a few years away from now. But judges at the federal level are appointed to lifetime tenure during good behavior. And I think they spell behavior with O-U-R. That shows you how old the provision is. And I guess I think 18 years would be reasonable, but again, it would require a constitutional amendment, and that's just extremely difficult to get. I think it would be nice if you could develop a tradition of judges just stepping down after 18 years and saying, this is enough, this is long enough. I think that would be reasonable. Although again, don't necessarily assume that will help your particular value agenda, particularly since, as I've indicated before, studies show that Supreme Court justices drift to the left over time. So you could suppose an 18-year limit, and maybe they're getting rid of another Justice Douglas or Justice Brennan or somebody like that. So I don't, be careful what you ask for. You might get it, and you might not be sure exactly how it's going to work out. I'm not sure what the best reform for the Supreme Court is. It would be nice if the nomination process were less political. One of my favorite colleagues at the LA Superior Court is a judge who was appointed to the state bench by Governor Brown around the same time I was, appointed to the federal bench by President Trump only shortly before President Trump left office. He is a truly outstanding judge. Because he's only at the trial court level, there's, it's less politicized, and his paper qualifications, I would think if any of you saw his qualifications, met him, you would say he will be a truly fine judge. And I think he was and continues to be. But the problem is that kind of merits-based appointment and depoliticized appointment isn't occurring at the Supreme Court level or the courts of appeals at the federal level. And that's a serious problem.
Any more questions? We have no vote.
Yes, my question relates to the previous question about whether or not the Congress or the combined executive and congressional branch of the government could not in some way influence the Supreme Court. my thinking behind that was that the Congress already has a responsibility for creating ethical base on the other federal judges. And why, with the control of the executive and the congressional and the Senate, could not there be some kind of ethical base imposed upon that the court? And my other was a comment in terms of the Citizens United being the opposite side of the immunity coin, because I think that that was one of the worst decisions also on the part of the Supreme Court.
Yeah, exactly.
Well, agreed on all counts. Certainly that Citizens United was a very poor decision, and the notion that corporations are essentially human beings is preposterous if anyone knows anything about history. There's nothing in the Constitution that even gives corporations the right to exist. And so if now this would be catastrophic economically in a modern economy, but if states decided tomorrow that they wanted to repeal corporate laws and just say, we're not going to have corporations anymore, we're going to go back to the 1700s and we're going to have sole proprietorships, and that's how businesses will be run, or partnerships. And you're a partnership, you're subject, unlike a shareholder, you're subject to full personal liability if anything goes wrong. We could have that, and that would be within our right to do it. But the kind of discipline we would have to do what you're talking about, it would be entirely possible to have a real enforceable ethics code. Would have to be something like, you would have to have right now a solid, disciplined majority in the House of Representatives, plus a 2/3 solid, disciplined majority in the Senate to impeach and remove. And very few people have been impeached and removed as federal judges. The most recent one, I think, is Alcee Hastings from Florida, who, after he was impeached and removed as a federal judge, managed to get himself elected to Congress. And I believe he's been in Congress. I think he's still there. Certainly he was there for a long time. And he was discovered literally with $50,000 of cold hard cash in his freezer. Cold hard cash. And, and it was sort of similar to what, or not as extensive as what the Senator Menendez in New Jersey had in his hands. But of course, as we now all know, one of the decisions, I don't know if we mentioned it a little bit, but the Supreme Court found a statute was, I guess, ambiguous in a way that the Supreme Court said it didn't outlaw, this was the Snyder case, which I think was mentioned, the statute didn't outlaw, it did outlaw bribery. And the Supreme Court said bribery means paying someone beforehand to get their vote, but it did not outlaw gratuities. And so therefore, and the gratuity happens afterwards. So following on that thought, I talked with my staff and I thought we could put up a little jar that would say tips. And at the end of making decisions every day on my calendar, we could say, oh, now that I've made my decision, if you're happy with the decision, you can put some money in the tip jar right over there. I can tell you what would happen if I were to do that. I would be gone from my position very quickly. Similarly, I would be gone from my position very quickly if it were discovered that I had accepted millions of dollars worth of gifts that are approximately equal to my pay as a judge during the time I was a judge, which is, of course, the reality for Justice Thomas. Yeah. It's neck and neck between his salary for his position and the value of the gifts that he's accepted are both in the 4 million vicinity. And I just think in general, judges should be in a position where their compensation is coming entirely or almost entirely from the government, and very limited exceptional cases of gifts. Though some of you may want to do so, I'm not going to accept any vacations to Hawaii that you may offer to me. or vacations to Europe or cruises to the South Pacific. Those things, no, I won't be exempt.
your mother, your mother.
Yes, no, none of that, none of that.
Coming to an end, so I'm gonna let Judge Tom to say some concluding remarks, okay? And actually, I don't know if you wanted to, I don't know if this is too private, but you were also a criminal judge. So you're also on the criminal bench before you're on the civil bench.
Yes.
Yes, you might want to just say the power of a DA and why it's important to have a good district attorney.
Well, and again, I can't endorse or oppose any particular candidate for any role, but I was on a criminal assignment for about 9 months at one point. And I will tell you, and this is not necessarily the way things are run by the current DA, or is it necessarily the way things will be run by any future DA, but it was a past DA when I was on the criminal bench. And my perception of the criminal bench, and this is the perception of someone who was a civil lawyer for 33 years, was that it is, there's a lot of assumption that a lot of what's being dealt with is high-level crimes that you hear about on television. And because you hear anecdotal stories, you know, most people, in fact, let's find out, how many of you in this room think that crime over the last, say, 20 years or so has been increasing dramatically nationwide and in California? Raise your hand. Okay, well, good. And at least 77% of the people would answer that question, yes. You seem to be a little bit better informed. Yes, you're the only one that answered yes today. And respectfully, you're wrong on the status of this. Right, I know. Right. And so this is one of those cases where most people are right. And it's a situation where, you know, there's a fear, and the fear has been built upon by fear mongering. And the reality is that crime over the last 20 years has actually gone down quite a bit. But what I noticed, and I was only in a misdemeanor court, although I also did arraignments and setting bail for felonies as well, but I only did trials and most things in misdemeanors, is I noticed that the way the courts are set up in California, the district attorneys run the criminal courts as a practical matter. And this is because they have the ability to do what's called a peremptory challenge to remove the judge. And since they have 100%, because there's no such thing as a private prosecutor, it's nothing but DAs. So they have 100% of the docket. So if they decide they don't like a judge in a courtroom, they just paper, they would call it papering the judge. They paper all the judges. Now I'm in a civil assignment right now. No one attorney has more than maybe 5% of the cases on my docket. That one attorney decides to paper me, so what? I lose 5% of the cases on my docket. It doesn't mean anything. The DA decides to paper me, I lose everything on my docket. And all the other judges are going to be unhappy with me. And I had this experience, and I had it because I did a couple of things the district attorney didn't like. One is I held him to the requirements of timeliness as to when he could serve motions to disqualify me. He didn't like that. Number two, I decided to use not only the district attorney's complaint, but also the police reports in setting bail, because my experience taught me that the police reports were more objective, gave you a better sense of what the facts were actually going on, and gave you a better ability to set a bail that was fair, which of course is not what the district attorney in my courtroom wanted. And I, at one point, and I naively trusted and accepted that I was being told the correct thing. And so at first I said, I want to see the police report. They said, oh, you're not allowed to use those. And I went along with that. And then finally I said, well, I'm not allowed to use them. Where does it say that? Well, it's in the penal code. Where? Well, somewhere, we just don't remember. I looked it up, I took a break, I looked it up, I came back out and I said, you know, you're right. There's a section right here in the penal code that says that the trial judge may not use the police report in any functions relating to the case, except for the setting of bail. So, and I discovered similar untruthful things I had been said, and I ended up being very disappointed with that district attorney, who was my calendar assigned district attorney. There was no way, as a practical matter, for me to speak to his superiors about that. And in my view, the district attorney at the time was leaving this attorney and other district attorneys untrained, unethical, uninspired, uninvolved, just unacceptable in terms of their conduct. And the other thing I saw was the criminalization of homelessness to the scale of where I had piles, one of the things that happens when you give a citation to appear in court to a homeless person who doesn't happen to have a day planner, a lot of them don't have day planners and they don't have cell phones with calendar programs on them, is they don't show. And so say the bail was set for something like a common thing was, oh, I could probably round up a bunch of you for this. Possession of drug paraphernalia. Any of you have a pen on you right now? Because if you unscrew the pen, that's drug paraphernalia that you could be using to sniff your cocaine, okay? So the bail for that on the scheduled bail was $250. Then, of course, they don't show, and there's similar low bails for things like trespassing or whatever. They don't show. And then what the practice was in one department, they even had a rubber stamp, failure to appeal, bail set at $30,000. Well, then the sheriff will get you. And $30,000, most people cannot, okay, you only have to pay $3,000, not refundable, to a bail bondsman to get your $30,000 bail. Most people can't raise even $2,000 for an emergency. And many can't even raise $500 for an emergency. So they end up in jail. And what they quickly, the DA will oppose a reduction in their bail on the grounds that there's some dangerous hazard. And then several days later, after the person has sat in jail for several days, unable to get out, at risk of losing their job or at risk of whatever the problem may be, then they will plead guilty. They'll enter a plea bargain, they'll plead guilty, and the DA will come back and say, time served. I'll say, well, it's interesting. You're saying time served is good enough. Several days ago, you were telling me this person needed to be jailed pending trial because they were such a danger to society, but now they can be let out right away. Well, the whole game was to do nothing more than to show they had a large percentage of convictions, as one of them was so kind as to tell me when he thought that, I guess he thought I was in on it all, but I wasn't in on it all. Just this is what we need to keep the system working. I decided that what we needed was something different. And what we did in my courtroom as I started doing is, okay, failure to appear. Mr. DA, can you tell me why the failure? No, we don't know why you failed to appear. Okay, bail set, matter continued, bail set for $250. Well, but Your Honor, these cases, and there were so many of them, they piled up. I had to stand up at my bench and peer up to see over to the district attorney. And he'd say, well, Your Honor, if you keep doing that and you don't increase the bail, they're insulting the dignity of the court. I said, no, they're not. I said, I have no idea why they haven't appeared. You're just speculating as to why they didn't appear. Well, if you don't reset it, eventually these cases will age out and they'll just all have to be dismissed. I said, and the problem with that would be? So ultimately that district attorney came around and he understood, and we would have a little discussion and he'd say, well, Your Honor, I'd like to dismiss, and then you'd have a big long list of cases, and I'd say, good, dismiss. And we at least started to get a little more focused on doing what the court should do. The other thing is, there's this desire of, oh my God, these people, they've committed shoplifting or whatever, we want them to be punished. We want them to be punished. How badly do you want them to be punished? Because 5-10 years from now, maybe they can get their record expunged, but it continues to show up on the internet. And so we're going to have someone who their landlords, their employers, et cetera, are going to find out that they were previously convicted of a misdemeanor. And that's it. And that's how long the punishment will stick with them. For the rest of their lives, they won't be able to get a decent apartment. For the rest of their lives, they won't be able to get a decent job, or they'll be much more restricted because of these kinds of situations. So, thankfully, I was only on a criminal assignment for 9 months. Now I'm in an assignment where when I make mistakes, which of course we all do, when I make mistakes, it's just money. It's not that big a deal. I don't make mistakes. I've never made a mistake as fabulous as some of the mistakes we've discussed today. Or should I call them beautiful? But whatever. It's just the whole justice system at times can be astounding. Do not allow yourselves, in the course of deciding what you're going to do in it, allow yourselves to be the victims of fear-mongering. I think one of the best things people could do, and this is what I encourage them, if they say, well, I don't agree with your point of view, I say, okay, I only spent 9 months watching how these courts function every day, day after day. Go down and watch for just a few days. Go down and watch, particularly a misdemeanor court, because that's where the rubber really meets the road. Most people who are being roped into the criminal justice system initially are roped in at the misdemeanor level, not at the felony level. And go watch and just see what happens to them. And try to figure out what's going on, and try to figure out if it really does make any sense at the end of the day. I'm not convinced it does, but we'll see, I guess.